previously shared, and like I had shared earlier, this is a really good time because it can clearly identify to you everything that you need to plan for, and then those are also the things that you will need to pay for in the future. So it's a very good financial planning tool as well. And then after we have this pre-application meeting, then the developer will then go and prepare the concept design of that idea and start really putting it down on paper and hopefully taking into account what we had talked about in our pre-application meeting. And then once that has been done, then you can come back again and then you can apply, do the actual development consent application. You can fill out your form, submit and pay, and then lodge it at this time. And then step 4 is that we will take that application package and we will assess it. And in our assessment, it's usually done internally, but we also have some other related steps as well. Is that sometimes when we look at your application, you might say, oh, you know, it's pretty large scale, or there are impacts here that we foresee have a public interest. So you might need to notify your DCA or your development consent application, notifying them, putting it out on public for public submissions. Number 2 is that we will also then need to refer it to our partners, our other government agencies for their very specialized comments. And number 3, if necessary, it might actually be a board approved application. And then after the assessments will be done, then you get notified of the decision. So this just is a very snapshot look of this 5-step process. But now I really want to take you into the details of step number 3 and step number 4. So I think this is where the interest of this training, and especially our friends from the tourism authority and also the tourism sector, will be more interested. So now let's take a closer look at step number 3, the actual development consent application.
If I may, come on.
Yes.
Yes, this building that we are in now, the whole building, I was the lead in following that process from scratch in getting the development consent, and I was supported by Della. And Della was still at before she left. So that for this building, I was following that process. Thank you. I thought of that. Thank you. So this is a benefit. We are enjoying the positive impact.
All right.
Thank you.
So now having a closer look at step 3, which is the development consent application. First and foremost, again, I just want to make a point that PUMA cannot go on to assessing an application if all the requirements are not complete. So you must completely give in not only just the application form, but also the required documentation. So I think that's a very good point that we need to make now. A lot of people sometimes just can't pay the form, fill in the form, pay it, and then expect the assessment, but they haven't brought in any documentation. So just think of it, it's very similar to your loan applications and every other applications that you do. And you do not get assessed if everything that you require is not there with it. So the actual application process itself comprises of 4 key steps that make up the entire puzzle. Now, step 1 is the developer has to come fill out and sign the form. Now here, the key word here is that the developer has to be the person who is either the project manager for the development or directly doing the development. Sometimes they send the the builder or the contractor who is only involved with one part but not the whole part. So that's the key part that you have to think about here, is that the best person to fill out the form is the person who will be there from the beginning of the entire development project right until the completed part. And that's really the person that we would recommend to come and fill out the form.
Why is that?
So thank you. So it's a very good. This is because this is the person who has a complete understanding of all the stages of development. Now, if I may use an example, just quickly to make up one. For example, I am a I intend to build a resort. And in my resort, I'm going to have 10 villas, a restaurant, a pool. So it's a very big development. But the stages of my development will be someone else is going to clear my land before I even start. And then the second stage is I'm going to get a different builder to build my pool and a different builder to do my actual houses. And then I'm going to get a different builder as well to do my restaurant farming. If these people come in to fill in development consents, they will not have an idea of the other activities that are being done. And that's why you need the person who is, for one, like the developer who's managing the entire development to be, because they have the knowledge of every element, every stage of the project from beginning to end. And that is the person that we need to come and fill out the form, and not the person clearing the land. And then he has no idea what else is going to be built after or that situation. And sometimes, for example, I am the developer, but it's not my land I'm building on it. I'm building on someone else's land, right? If you get that landowner to come, again, he will not, he's just giving the permission to build, but he might not know all the details of the development. So sometimes it's appropriate if the person, the landowner, is also the developer, but we always recommend that it would be a person who understands the entire project from beginning to end to be the builder. Yeah.
Thank you.
Yes. So that's step number one, fill out the form. Very importantly, you have to sign your form. Number two is that from the form, it provides also a checklist of all the documentation that you need. You have to make sure that along with the form, you have satisfied all the required documentation. That is also the role of our lovely ladies and gentlemen at the office. They will also advise you, based on the nature of your development, all the documentation that you need to complete your application package. And then the third step, when you've completed 1 and 2, is that you pay the prescribed fee. And then you can move on to step 4, which is to lodge the application. You get your receipts and then you await the decision. Now, let's take a closer look at part 2, which is provide the documentation. Now, this is a very key part of this step. So typically, there are 4 types of documentation that are required to be attached to any application form. And that is number 1, land ownership details. Number 2, a site plan. Number 3, a concept plan. And number 4, as we talked about already, if required, you might need an EIA report and the relevant management plans to be attached with it. Now, just to note here that the agency may also advise on any other document different from these 4 based on the nature of your development. If you remember, we deal with all types of developments in different natures, from fence buildings, actual buildings, clearance, even subdivision of your land, which is actually not a physical activity, goes under the DC process. So it really is tailored towards the type of development that you will bring. But these are typically the 4 that you will see on everyday types of development. So now on to land ownership details. So the land ownership details and the documentation you need to provide really depends on the status of who the developer is. Now, if the developer is also the landowner, meaning the person in charge of the development also owns the land, this is what we will need from them. We will need what we call a computer folio certificate. So basically what it is, it's a paper document that confirms the registered landowner for that said land. And this document is issued by the Ministry of Environment from their lands department. For a very small fee, you can go to them and then they will print it for you. Now, together with that, another document that you can bring if you don't have the computer folio certificate is the actual deed of conveyance, or the deed, the land document papers, and it must have the name, your name on it, as well as must have stamp duty, which means that it's been registered, the deed. So it's not just a piece of paper that you went and put your name on it. So together with these either two, you must also provide a certified and your registered survey plan, which gives you the actual alignment of your land boundaries that your development will be based on. And that's for the landowner. If the developer is leasing from somebody, they must provide us a signed and current lease agreement with the names of the landowner and also the name of the developer. And together with that land lease agreement, they must have a specific letter of consent from the landowner to say that they are giving you the okay for this specific development that you are applying for. So you can't just give us the agreement and expect to take that. Because sometimes the agreement just means this person is allowing you to lease the land, but they also must give their consent on whether they're allowing you to do this specific activity on top of this lease agreement. So you need the lease agreement, you also need a consent letter from the landowner that they agree to this development. And to show us that the name on the lease agreement as the landowner is really the true landowner, you can also get us a computer folio certificate from MNRA to say that that landowner is the true and correct landowner for that land. And then just like the landowner documents, so you need a computer folio certificate and a survey, registered survey. So now we come on to customary land. Okay. We have a question?
For land lease,
Yes.
for landowners, do we need to have the signature for all the landowners?
Oh, yes. Oh, of course, it's the signature that that we assess. So, for example, for the written consent letter, sorry, for the landowner, let's talk about the landowner first. If they are the landowner, the developer, they will sign our form, and that is in part giving their consent for the development, right? If it's for the leasee, then the lease agreement and the consent letter must be signed.
All.
Yes,
All
by,
landowners.
especially the landowner, because this is documentation to say that the landowner, it's the land ownership, has given their consent for the development. So it must be currently dated, even the consent letter must be dated within 14 days of the application and signed. So we can't just get like a note with a name and no signature. It has to be signed. And coming on with that same point in mind about the importance of signatures, it's the same for customary land. Now we all know our cultural lands, that the ownership is under the custodianship of our Matai systems or our chiefly systems. And we respect that. And if you are intending to develop on customary land, you need a written consent from the responsible high chief or sao for that particular plot of land. And that's if we usually understand that our land tenure system for customary land, each plot of land is assigned to a title, a certain title. So you need to get that consent from the relevant title holder for that land. If there is no assigned title, there are some cases like that, or if it's vacant, as in there's no person holding that title yet, or person has passed away and they're trying to find a new title holder, or even if it's naturally unassigned, then there's two ways we can go about it. One of them is you can also seek the consent from the entire village council of Matais, so the collective council, or you go to the family group or the clan that owns that land, and you can get their collective signatures to say that as a family, as the Aina, that these lands are under, that they give them permission. So those are the type of consents you need from the customary land. And which one you get, it must be supported by confirmation from the lands and titles court, that they confirm that the title that you've sought consent from is the correct title. Because very often we have gotten that. Someone has said, oh, our Matai has signed, they agree to it. But then something happens later on the line, people complain and say, that Matai is from a different village, or that Matai is not the Matai looking after this land. So that's why we need a further documentation to support your consent letter. It's so to protect the actual land owners. And that is a summary of the 3 types of land documentation you need based on your land ownership status, whether you're the landowner, you're a leasee or the person leasing from a landowner, or if you're looking to build on customary. So we have a question.
What about for coastal areas, like where the land ends and onto the sea, the ownership of that area? There's going to be a tourism development that goes into the ocean.
Yes, that's a very good question. And I think under the law, our constitution law, those areas are actually the landowners of the government. So a certain, from the high tide mark, it's considered government land, government reserves per se. But what we're actually doing now, because in our country, our culture is strong, and a lot of our coastal areas are still under the custodianships of our matais and the village councils. So even though now my colleagues from MNRE can pitch in, but my understanding is that we're very respectful as well of the authority of these land village councils. So it's like a partnership that they look after it, but if we really take it under the law, it's government owned land. So for this one, if you can get both, it has to be both. So you have to also, if you're intending to build on a government reserve, government is a landowner, so you're going to be leasing. So you need to do the green box. And the landowner in this case is government. And you might actually have to do both. You have to seek governments, and you actually also need to get consent from the village who is looking after that area, the coastal area. So it's a blended. Yes, and we have favor.
So thanks today. I think the other thing that we also have to look into from the PUMA side in terms of customary land, and that would also be relevant for our tourism sector, because most of our tourism developments are on customary land. And even though we would like to think that it's easy to get those consents from the that has that authority over the land. Some cases, there are historical court decisions that have been brought forward, and sometimes the current title holder will supersede those historical court decisions. And then at the end, the families that have been occupying those lands for like hundreds of years will tend to be negatively impacted by the current title holder. And so, I'm talking from current experience, and so those are things that I would really like for our PUMA officers to be aware of, because sometimes people that come to apply for applications are not honest in the provision of those documents. So that's where maybe in your site visits, you may go then and assess the site, and then make sure you consult with the families that are directly affected, because sometimes those developers, they skip those people that they know will say no to their development.
Yeah, very, very good points. And I think that's what our process, and that's why I'm saying at the end, not only do you get your written consent, which are letters, but you need to further support it with an actual confirmation from the Lands and Title Court. And they have the records of any court decisions on a title, the registered title. They can even say, sometimes a person will say, oh, I am the highest chief of this village. But then you go to court and it's contested, it's not approved. So that's why the courts for us is the most final decision maker, and that's where all the legal information is stored. And that's why we need this confirmation from them. And it's exactly to do that. It's to avoid issues where Ophir is speaking, because of course, we we have faith in people that they will try and be as honest as they can be when they apply. But that is not always the case. You know, someone will always try and find the shortcuts and or make something up. And sometimes it's easier to fabricate a document than to actually go and ask for permission. So that's why we need all of these other supporting documentation and legal documents. And that's why we always ask lease agreements are recognized legally as well. Usually they're facilitated also by a lawyer and they're registered to import things like that. So that's why we ask for these legal documents, and it's so we can avoid situations such as this. But yeah, so that is noted. But that very key question about, you know, what about environmental reserves? Who is the landowner there? So the answer therefore is, you know, officially and legally it's government. And so you must, the administrator or the landowner for all government lands and reserves is MNRE. So you must seek their approval. But at the same time, to be courteous, you also have to get support and approval from the actual village that those lands are in, because they are the cultural custodians. There are the people who are looking after that on a day-to-day basis. So that, in a nutshell, is what documentation you need. Cheyenne?
From the private sector, I really appreciate this breakdown. This might be more of a question towards MRE. I know that for the Untitled Chapter document, there is a detail last week. Is there a fee for the folio certificate? And if there is, how much?
I think I'll respond to that. Yes. But it's very cheap. So cheap on the
Oh yeah, 5 or 10 dollars. So that's what I said. It's a very small thing, so it should not hinder anyone from actually getting folio certificate from them.
Yeah, just maybe contribute a little bit. There's a bit of it's about the generalization program guidelines. When an owner is, it's not clear whether you're referencing freehold land here or just what is it? Freehold, customary. Because
landowner means freehold land, because yeah, customary land is under customary land. So freehold land also means government land, church land, not just personal free private land. Church lands are also classified as freehold. So for example, if you're leasing on church land, you must go to the landowner, which is that church body, and get that consent. The same for government. Government is considered as freehold land. So if you're leasing from a government land, a landowner is MNRE or Salasi, or that's stick. Those are the different types of landowners.
So
expand a little bit, like, because computer folio certificate like registered freehold. It indicates the nature of land is freehold, whereas customary lands are non-registered land. So you cannot expect to go to get a folio for customary land. But the agreement to support any development, as she said, is that letter of consent from the
So that's why we're not asking, you can see, we don't ask for a computer folio for custody land because it's not always available. There are cases though that if it's registered under the system, they'll just say, oh, this particular land is under the DN officer, but it's not available for all. So that's why we don't ask for it. And what we need from you instead is that consent letter, and a signed one, and also the lands and title reports to say persons or persons who have signed this are indeed people who should be signing for that.
And if just sorry, and if there are such things as customary land, like there are court crimes, those are called court crimes. The indication that the previous nature of the so how customary lands were transferred to become government lands for the corporate lands. So that's how the government got their lands. It's through these corporates.
Yeah.
It's an instrument of buying it from the local back in the day.
Yeah. Thank you. Thank you.
Okay, so that's your first type of documentation. Once you identify who you are under these three boxes and gotten your documentation, the very next one that you need is a site plan. So for a site plan, this is what we call a layout plan, and a site plan is very important because this is where it shows the entire layout or where your development lies within the boundary of the land that you're looking to develop. A site plan must show all the elements of your development. So for example, again, I use the example of a resort, and if you have all those elements, you have villas, you have a restaurant park, a pool, footpaths, a garden, a swimming beach area. A site plan must show the entire development within the boundaries of the land or within the area that you are proposing to build on. And very importantly, all of these elements, they must be scaled and they must have dimensions, meaning measurements, to show not only how large they are, but also the distances between one element and another element. And elements can also include things like you must show the boundary line, the layout of all structures like your paths. They must show the drainage pathways, the wastewater systems, septic system locations, basically everything that's included within your development from the beginning to the end, it must be shown on your site plan. And that is a picture of a typical site plan. So that is a typical site plan for just, let's say, a house that intends to have a garden and a pool area with a deck. You can't really see it, but it has numbers on it. So those are the measurements of the sizes of the elements within the site plan, and also where it lies within the property line. One other key point is that we really encourage that the development itself on the site plan must be orientated to the actual shape and size of the land. Very often we have come across some things where the site plan is a very nice rectangle, let's say, and it looks very straightforward. It's a straightforward rectangle. But then we go to see the land and it's a curved land and the actual shape of it is a triangle. So, you know, this site plan, most people don't really think much about it, but this is our key assessment tool. This is how we're able from the very first instance to look at your development and how it will lay out on the land. So it's very important that you use the certified survey plan and then orientate the actual developments on top of it. So another question we've been asked often is who can draw up a site plan? So it's usually the designer of your development. Obviously, you're going to pay somebody, a professional, you know, could be an architect, or could be an engineer, to do the design drawings for your developments. This is also a step that they should do, is also provide you with a site plan.
Let me ask a question. In terms, that's very good. Thank you for sharing with us the importance of site plan. Is there any standard of, say, take for example, for that house there, the distance of the house to the fence, are there any standard measurement that needs to be put in place so that you must not build the house within this distance?
Yes. So yes, there are many standards that guide how your development is to be laid out, and we have a lot. And if you remember my earlier presentation where I showed you like a flow chart, like a hierarchy of our plans, and it had the act, our regulations, and then on the bottom we had all our policies, standards, plans, guidelines, and strategies. we have a lot. So I think in our current library, we have 50 plus different documents relating to different types of developments, and there are standards in there related. So, and yes, that's what your site plan and how you plan your developments must comply to those different standards. So the specific example that Joker has shared about the distance from your house from a fence, there are standards, and those are called setbacks. And there's a minimum distance that you must give space between your fence and the actual building. And so you're not allowed to build right on the line. There's a minimum setback distance. And I think that distance is about 1.5 meters or 2 meters, if I remember. So it has to be a minimum of that X amount of meters. Even the height of your building is, there's a standard for the maximum heights of building. There's a maximum height for your fence. There's a standard for what materials you must build your fence towards. So we do have a lot of standards. Yes.
Sorry, so that applies to also homes, like
yes, so from residential homes right up to our commercial homes. There are, and perhaps after, like, if you would like as well, I can start sharing with you the particular policies that we have that identify within them the particular setback standards for each element that you can look at it and see what you need to comply with. But even the site plan, there's a document that we have that gives you all the elements you need to put into your site plan. So, and there's a lot really what I give and give out. Even this site plan, it's a very nice, simple set plan. There's no contour lines on that. So contour shows the elevation. So sometimes, you know, if you look at that, it's a nice plan, but it actually could be a hill. So site plans need to accommodate that for us so we can see when the water would flow, who would be most impacted, and things like that. But I'm just giving you a very simple example here. But if you want to know more, there's two options. You can like to ask me after, or come into our office or call after. I'd be happy to serve you.
There's 2 questions. Who are accepting hand-drawn site plans? And my second question is, do you have any specific tourist standards that can be given to our tourism authority for their?
Yeah, thank you. So the 2 questions about the hand-drawn. So at the moment, another key thing to remember here is for customary land, there are no land boundaries. But that's the key part of this type of site plan is that the development has to be within the land boundaries. So in the case of our customary people, because customary lands are unsurveyed, there are no land boundaries. That is the case when then we can do what we call concept sketches, whether you can do a hand-drawn one to show us that within the existing features of our customary land, this is where the development will be. But we only accept that for very small scale developments. So for example, a personal family home. Someone in the village wants to build a house and it's between house number, this house and this house within the village. They can come and show us. So usually what they can either do is come to our office, we print a map, and then they show us approximately where the house lies for that. And that is the only cases that we do this. And it's to help people from the villages who may not actually be going to an architect or an engineer for their small home design also, for example. But if it's a big development and if it's, someone doing something of a commercial or industrial type, the expectation is you must give a proper site plan. There is no excuse of why you cannot produce one, especially if we know that you are intending to have a design for your house. So this is a very small addition to within the actual design itself. And the second question, sorry, what was your?
Specific tourism development standards.
Oh, the development standards. So we don't have a specific tourism standards only for tourism, but it covers under, for example, we have what we call like a housing planning for buildings policy, which has standards for structures intended for like buildings. And obviously if your tourism what you call development has a building in it, you need to conform to that housing one. We have a parking policy. So if your development has parking, it will be, you know, even if it's for tourism, you will have to go on parking. We have a fencing guideline. So for example, you just have to take the elements of your development and then look at what policies that we already have in place, and you must follow that. But we don't have them specifically for natures, like for example, like we don't have a set guideline for tourism to guide them. And I think STA may have that to guide their operators, but it's not in the interest of our office to set that.
Okay, sorry, just to help with your question. Yeah, we do have minimum hotel standards depending on each category. So for beach folly, we have our own set minimum standards, and I'm sure Geneva is also part of, has been going on our inspections, because PUMA is also part of our hotel standards accommodations committee. So these are the committee that actually set the standards, not only with the drainage and for everything. So we do have our own minimum hotel standards depending on each category. So from deluxe to superior to standard, all the way down to the beach follies.
So you have a standard for setbacks between beach folly and setback of septic tanks from the coastline?
Yeah, can I just leave it to my colleague Vina, as they will, because they will be carrying out a new accommodation stand inspections later on the month to revise. So I'm not quite, don't want to give an answer in case it's wrong, but I'll just give it to actually specifically within the team that carries out the.
Thank you for your question, Alferia. That's the purpose of this committee. So we have PUMA as part of it, FISA, EPC. So these people that forms the committee. So we set the standards. So those ones that are in that committee will not only just the tourism sector or the STA that will set the standards, or actually as measurements that you mentioned, for example, the septic tanks and that the MOH, they do really have standards of, you know, they indicated the number of the measurements of how far the septic tank should be, you know, from the property or from the beach valley or from. So prior to that, we're gonna have a meeting again to revise our standards before we actually go out to our properties.
Sorry, I think if I can just add on to this, I know about this committee, and I think what tourism standards, what they do is they actually leave it to the specific agency or ministry, and they will use their standards and then they tailor it to make a tourism accommodation standard. So for example, your question about setbacks from buildings or building setbacks of the septic, that's under, we cover that. So we cover it under our housing policy. It tells you about, you know, the setbacks between buildings, setbacks of your wastewater systems from boundary, from, and they also have, in this committee, there's also the building division of MWTI, who do structures, the building code. So that's what they do. So they just take these standards, I believe, and then they form the tourism sector. So that's what I was trying to say. Like, we will not do that probably, like tailor our. But when we do go to these committees, we will tell them what's relevant to them, and then give it to them to manage, and for them to, as you know, the tourism authority, for them to enforce. You know, these committee site visits that we go to, it's a joint inspection. So we do an inspection, we go with them. If we see issues that are, you know, relevant to us, for example, someone not complying with the conditions of the STA, we use this opportunity with STA to, you know, go and cross the border. Same with the building permit people. If they go and they see a structural problem, then we use this committee for all of the members to come and do an inspection at one given time. Thank you.
Thank you. Thank you.
Thank you.
Hi, Della. I see. Please pitch in.
Hi, Greg and everybody. If I may assist Utule with some of the questions.
First thing is PUMA used to assist the customers or the clients with their site plans, but recently it has been approved and we've been directed not to do this anymore. We can only advise. With regards to the specific STA standards, as noted from the STA side of things, there is an existing STA standard, but during this, this standard has already incorporated the NWTI, specifically PUMA's housing guideline and the National Building Codes standards in it, specifically setbacks, distance from septic tank, setbacks from the beach valleys, if it's a beach valley, and the hotels, as well as boundary setbacks. Thank you.
Thank you, thank you.
If I may add,
Yes, you may.
So with the accommodation standards that's been discussed by our colleagues, as alluded to by Dela and Utule, yes, these accommodation standards have been revised. We have yet to finalize because we were awaiting the final building code and also the Ministry of Health as well as a minimum standards. So we've yet to finalize the revised one, and as mentioned by the ladies, because the accommodation standards or the tourism authority do not have any regulation in place where we can so we are heavily reliant on the regulations from our key committee members, which are comprised of the PUMA, the Ministry of Natural Resources, the Ministry of Health, the Electric Power Corporation. Those are the key, also with the Hotel Association. Those are the key people who are in this accommodation standard committee. So for information, we have already revised them. We've just yet to finalize this new revised accommodation standards. Thank you.
Thank you.
Okay, so I think if everyone's ready to move on.
Please.
So now that you have your land documentation documents and now your site plan, the very third document that you also need is then the concept plan, or also known as your concept drawings, for all the elements needed within your development that's all included. So I go back to our example again of the results where developers coming in, wanting to build some villas, a restaurant valet, and a pool. Now, a concept drawing is needed for each of those elements. So if the villas are going to look different from each other, be built, each will need its own concept drawing. A concept drawing for your restaurant valet, concept drawing for your pool, a concept drawing for all the footpaths and all the other elements included within your development. And basically what a concept plan is, it just provides the aesthetics or the look of your elements and also the layout internally, so just the floor plan. Now, there is a difference between what is called a concept plan and detailed designs. So designs give all the information on how it will be built, all the materials needed, the structure of it. That's not what we need, and we do not assess the structures of any buildings. That's what the building permit will do later on. But we need the concept designs, so just how it will look and how it will lay out. So here we have an example. We need the look on each of the sides of each element. So the right side look, the left side look, the front and the back, and also the view from the top and the floor plan layout. So for every element that you have, we need to provide what you call your elevations or the looks from each angle, and also your floor plans. And if it's footpaths and things like that, we just need to see what material it will be made of, and as well as plans, other concept plans for your drainage pathways, your wastewater concept plans, things like that. And these drawings, we highly recommend that they must be drawn by a certified architect or IPES or Institute of Professional Engineers, Samoa, registered or chartered engineer. And this is because this is a requirement in that profession. The profession of people that do drawings, they also have their codes and standards of who is able to do that. And we are just following along with their recommendation about that. And very importantly, just like your site plan, the drawings must have your metric dimensions, so how long and wide things are, and must be scaled. So that, in a nutshell, is your concept plan. Would anyone like to ask a question before we move on?
It's just for the site plan, like what Kitiona mentioned, if I have 5 filers and I want to add another 2, do I resubmit a new site plan to include the new 2? Oh.
And you'll be, so it depends too. So if you're adding it while we're assessing this, you just bring it in and we will amend the assessment. But if it's been approved to you and let's say 3 years down the line, then you add, we treat it as a whole new application where you come back and with the site plan that now shows the extra 2 being, and even the concept plans for that extra 2. That's what we do. So concept plans are needed for the new things. So for example, you don't need to bring the concept plans of the original 5 that we've already assessed. You just need the concept plans for every of the new elements that you bring. That's just a clarification. Yeah.
So say for example, residential. So you submit a concept plan, you draw up the house, kitchen, and the fence, but yet you only build the house and fence. So you still need to submit a concept plan for that kitchen, even though it was
Submitted before. No, so you wouldn't need to because we have already assessed it. So just to clarify, when you bring in your concept, let's say you're building your entitled fence, a house, let's say you're also building shed and the side, kitchen, things like that. When we assess and we approve it, it means that we have assessed all the elements that you provided. And then we give it to you. And let's say, based on your own financial planning, you're only able to build your house and fence, but not the shed yet. That doesn't matter. Like, so within 2 years, so you must build it. But after 2 years, your consent expires. And then you have to reapply. And usually it's very straightforward if you come back and just say, oh, now I have money to actually do this. And I intend to do it exactly where I said I would do before. So then we'll just have to reassess you and issue a new valid DC so we can go on with that.
So every DCA is valid for 2 years?
Yes, so every DCA is only valid for 2 years. So you must build all the activities that's been approved within 2 years. After 2 years, you must reapply, even if it's for the same thing that you will get assessed again, but it's just because its validity is only for 2 years. That's a very key point there. All right. So this is number 3. Number 1 was land documentation. Number 2 was our site plan. Number 3 is our concept plan. Now, the 4th type of documentation you can need for your application process is an EIA, but this one is special. It's because you may not need one, and the fact of you needing one is determined by the agency. And we will request an EIA based on the scale of your developments and also the potential generated impacts your development will have. And when we see that, one of these 2 things is triggered, either the scale is very big and the generated impacts may be big, we will then request an EIA that you must undergo the EIA process. Now, the EIA process itself for PUMA is regulated under, if you remember as well from my earlier presentation, is regulated under the EIA regulations of PUMA under our act. And our regulations sets out all the instructions of the things that you need to comply with the EIA. And basically what it says is that there are 2 levels of EIA reports. So it's not just one report every time. So based on the scale, you can be given 2 options of 2 types of reports to do. One is called PEA, or Preliminary Environmental Assessment Report, or a SEA, or Comprehensive Environmental Assessment Report. Now, it's pretty self-explanatory in its name, the differences. One is a preliminary one, and one is a very comprehensive one. And based on this initial assessment of your scale, of your development, PUMA will tell you which type of report and study you need to do, whether it's a PEA or a SEA. Now, just to touch base on the key differences and similarities is that PEA is when we are suspicious that maybe it will have some impacts, but we're not very sure as well. And that's why we're going to ask you to go do a very rapid study of what the development impacts will be. So for, and that's judging from a development that we think may not or likely to not have significant impacts. Some impacts, but not big impacts. So for example, building of a storage warehouse, it's a very straightforward building. Maybe there will not be impacts, but we're not sure. That's the purpose of the PEA, for a rapid assessment of the development to see what the generated impacts will be. But it's very importantly, it still must include mitigation measures for any impacts generated from developments. And very importantly as well, whether it's a PEA or a SEA, there are still consultations of the neighbors or any affected person must be and the report must include these outcomes and also signature of all the people you have consulted, feedback that they have provided you. And very importantly too, sometimes a PEA might have been the option that we've given you, but the finding of the PEA actually said, oh, you know what, I know we thought there were not any big impacts, but we're actually taking a deeper look and there will be. So now the recommendation is to move on to comprehensive study. So PEAs actually have that power to do so, to say, oh, I know we had a quick look, but it looks like it's going to be serious. So the PEA recommends a SEA, and then you will move on to the comprehensive environmental assessment report. And SEA is the larger, higher level report that you need when you do know that your development is going to create a lot of impacts on the environmental, social, and economic spheres. So, for example, things like major land clearance, wastewater plants, multi-element development, for example. And what it is, it's a full EIA. That's what you hear often. Well, you need a full EIA. So this is a comprehensive environmental assessment report. And it's a full investigation of all impacts, and it's a risk assessment as well. And you have to do a very comprehensive exploration of all options to mitigate all the impacts that the assessment has found, and also give what the alternative option is from actually doing that activity that generates an impact. And different to the actual assessment report, there are attachments, what we call management plans. And depending on the nature of it, many commonly requested management plans are site management plan, safety management plan, drainage management plan, waste disposal, traffic, for example. So it really all depends on the nature of your development, but a full EIA study must also give their management plans as well. And just like the PEA, consultations really is the underlying pillar that holds all of this. It must be consulted. You must show evidence that you have gone out and talked to people who are affected, and you must also show that they gave you feedback of their concerns and you have tried to address it, and not just say, oh yeah, that I went and that person said he's not happy. And that's the end of my report, he's not happy. You must also show some effort that you have tried to make a compromise. Or if not, then that is what the job of our office will be, is then to try and help resolve all these concerns that have arose from the consultation. But that in a very nutshell is the differences of the two EIA reports that our office requests from you. And like earlier discussions, I've said, who gets to do these PEA and SEAs? Like I said, because it covers all elements of your environment, the economic, the social, the physical environment. Physical environment, includes land, sea, air, freshwater body. need specialists in each of those areas to contribute to this report. So really, it's a team effort to get an EIA together. But we always recommend that the person that is putting it together and bringing it, presenting it to our office is someone with an environmental background who is able to synergize all of this information given and then presenting it in a report form. So yes, so that in a nutshell as well. We also have, like I said, we have many documents that support these. So we have an EIA guideline that identifies really the step-by-step processes of, when you're creating an EIA and how it will be reviewed. And we can share that with anyone who is interested as well. And we'll probably, together with the regulations, we'll provide you with much more information. But I just wanted to give a snapshot here of what the EIA reports and the types are that we will ask you to provide if you are a developer for the development application process.
After submitting all required documents, how long is the process typically?
We're just about to come there, so you're actually prompting us to the next step. So actually, before we even get to processing, after you collect all your documents and you satisfied all the documentation needed together with the application form, the very next step you pay is to pay the fee. So this is a list of what our fees look like typically. The fee is actually scaled and it depends on the value of your entire development. So for example, if the value of your entire development is 50,000 tala or less, your fee is 30 tala. If it's above $1 million or million and to 5 million, it's only 250 tala. And if your multi-complex is above 10 million, then it's 2,000 tala. That's just an idea of what the fees are like. And we will also, again, be giving this out on pamphlets that you can take and keep and have a closer look at. But after you pay the fee, then we move on. Your application is lodged, and then you have to await the assessment by PUMA, and this is what we will go into. So processing times. Again, these times are given in working days. And the processing time really depends, again, on the scale and the nature of your development. So for small scale developments, for example, a simple residential building, you just intend to build your house and a nice fence around it, light renovations to your existing building, an extension, like you're adding a deck to a house that you already have, fences, small land periods, that will take up about 10 working days. So about 2 weeks. For medium scale developments, such as, 2-story house now, or multiple houses complex, commercial, industrial yards, small quarries, even now the change of uses. So for example, you had a residential house, it's a residential house, and now you're intending to change it into a shop. Just in the front area, you're now changing the use from residential to a mixed, which is commercial. And if you're intending to still live in it, but now you're going to have a shop front. So even though there's no physical changing or no addition, no extension, you still need to come and apply your development consent because you are changing the use of your land and buildings. So that's subdivision of land. So again, no physical works. It's just that you had a 1 acre that you would now like to make into 4 quarter acres and you want to sell them. So to subdivide your land, you also need to come in to do a DCA, earthworks, and small beach valley accommodations. So for example, a beach operator would just like to use the beachfront and they want to build 4 beach valleys, the traditional beach valleys, and maybe a toilet block, a small toilet block, then that would take about 20 days processing. And then for our larger scale type of projects, whether it's large scale residential, commercial, industrial, things like hotels, restaurants, resorts, factories, construction company lots, large infrastructures, that would take about 40 days processing times. And I think it's also very important that these can be extended. You can be asked that it will be taking more time, especially if during the assessment, we find out some missing information or something that we hadn't previously thought of that has come up, and we are requesting you for more documentation. That would extend the time frame of our processing times, extend it more. But I'll pause here if someone would want to.
So what we're just talking about, time frame. What's the time frame given to a developer to submit their CO? Their.
Well, again, that comes, you have to submit it before the application is launched. So that's what the importance of your pre-application meeting is. So that's when we will identify you to say, oh, you know, you'll probably need an EIA for when you actually apply. So the understanding is you have already prepared the EIA, and then when you launch it, like I said, we won't assess it if it's not complete. And then with the completed package, these days will then start, you know, this time frame will start. So it's 10, you know, so even, but usually things that need EIAs are either medium scale or large scale. So the understanding is it's already been done before you have launched your application. Yes. So that is, oh, hi, Greg. Sorry, I didn't see you.
That's okay. Just a question, just more for clarification. So talking about the EIA and, you know, you've decided that it needs, say, a CER instead of a PER. Whose responsibility is it to determine what studies are undertaken? Is that done in conjunction with PUMA and MNRE and the developer and any other relevant agency, or is it purely left to the proponent and their consultant to figure out?
Thanks, Greg. That's a very good question. And I think it's actually a partnership between. So again, when you come in for your pre-application consultation, where we will talk about all of this, what you need. We will also give advice about who all the other interested stakeholders will be that you need to go consult. And given, for example, let's just, okay, let's use an example. For example, it's a tourism operator who wants to do like a eco walk through the mangroves. And he wants to build some boardwalk to walk through the mangroves. And that's the intended project. So he's trying to apply a DCA for the building, you know, for the boardwalk. We'll probably give advice to say, oh, you need to go to MNRE and talk to them as well on what their concerns will be with the conservation of the mangroves, because that is under MNRE. And even, you know, if it has an impact on the water quality, you know, construction, or water or some things like that. So it really is a partnership, and it's the importance of this pre-application meeting with you. It's tailored exactly to what your development is, and our advice on who you should go see and who we should work in partnership with will be given to you and tailored towards you. So right now, because again, when we do get these reports and things, they will be given back to the agencies or the ministries that whose focus or whose mandate is that particular area. So for most of our EIAs in general, actually, it's standard that we give it to MNRE for their review. So, you know, in your best interest, you hopefully should have seen them before to know what they would need. So when you had prepared this EIA, it was inclusive of that. So you don't get stopped and be told, oh, you're missing this, you need to go back and tell your consultants to go do the study and to do it again. So yeah, it's in your best interest. And that's why, again, I really flagged this pre-application meeting before, when just started thinking about your to come in and have a chat, because it can really identify all the things that you will need further down the line for you. So yeah, I hope that answers that question. Okay. So that's it for our processing time. And then so we've just talked about this from this discussion now, but these are some other additional requirements that may be triggered for your assessment. And number one of them is notification. So when DCAs are submitted, we will determine, it's so important that you as a developer have talked to your neighbors, especially if your residential houses and things like that. The understanding is you really don't need to go talk to someone. As long as you know that your house is situated well within your land, it's not even close to your neighbors, then we will say that, you know, notification is not necessary. But once you know that the development that you're going to do will generate some impact on your neighbors, it is so important that you go and just to talk to them, just to say, oh, hello neighbor, I'm in a few months time, I'm going to be building a 2-story house, and you know, I just wanted to let you know. And then at this situation, people will then communicate, like have a concern with you, just say, oh, you know, how's the noise going to be? I have a baby that's sleeping, things like that. So we usually address here to say, when you go out and do your notification, you must also present evidence that you have notified all your neighbors or any other persons that may be affected. And there's usually a separate form that you go and tell these people, and it's a record that you talked to them and you didn't make up, you know, a line to say, oh, they're okay with it. And they must sign and also write down any concerns that they have, and that will be also taken into account in our assessment. Those are, again, it's also based on the scale of your development. If it's a development that's large scale or has a national significance, then we need to elevate this notification to a public level. It has to be publicly notified for all people to have an opportunity to put in a submission if they feel that they have a concern that needs to be addressed by your development. So this notification process is also regulated under our PUMA notification regulations. And again, public submissions, public notification of your DCA will be required based on the scale and the nature of your development. Second requirement that we will need is what we call the referrals. Again, based on the nature of your development consent application, we will refer to other government agencies, especially those with specialized knowledge on a particular area, for their comments and their review of your application. So example here, so for any development that has an impact on, you know, any part of the environment and conservation, biodiversity, land management issues, government land, water resources, for example, waste management, we will refer it to MNRE for the specialized comments on the application. And then what we, so for LTA, it's anything that impacts the traffic, public drainages, roads and road reserves, public road parking, for example, FESA, DMO, MO, health, fisheries, and many others. Whoever else that we feel your development may impact, we will refer it for their comments. And the purpose of this is because these are the agencies with their specialized knowledge in that area. And what happens is if that agency has a look and they also have some concerns and say, oh, I think you know, your developer needs to be considerate of this or make a plan to manage this and this, they will give that to us, and that will be part of our assessment of either the conditions that we give for our consenting, or we in turn will request the developer to address these comments before we give our decision out. So it's a very good planning tool where we involve all our agencies to be a part of the decision making. And the third type of another requirement, special requirement that you might need is a board approval. And this is required for all development with capital value over $1 million So as soon as it's over $1 million, it's a board approval case, so it must go to the board for approval. Or if it doesn't reach 1 million, but we deem it to have, significant environmental, social, economic impacts, it will also be elevated to the board for their decision. So the office will do an assessment findings and then take it to the board for the board to approve it or not. And again, a lot of our referral agencies are also part of our board. So this is also a higher level opportunity where our stakeholders can come in and be a part of the decision. And then that is just a nutshell on what our assessment looks like. So you've submitted your application, it has been assessed, and now we come to the notice of the decision. So now you are called in and notified what the outcome of your assessment is in. And the decision really can come in two ways. And one is congratulations. Your past assessment and your development consent has been granted. So what do you do now? So once you have your DC or your development consent, you can move on to apply now for all the other relevant legal permits that are related to your development. So for example, if you have some sort of buildings in your development, you may now go to the buildings division of MWTI for building permits. Or, if your development has some sort of sand mining element into it, land management of MNRE also has a permit. For example, if your development has some sort of drainage aspect that will be connected to the road, you must also go to Land Transport Authority. They also have a permit that you apply for. But if your development doesn't really need any other permits, then you may commence your development, but you must ensure to comply with the conditions given. So our development consent is not just a paper that says, yes, you are good to go. It's actually quite a thick document because it actually comes with attachments of all the conditions that you must comply with. So it's really important that you don't just focus on the front page where it says your condition has been granted, but the most important things are the attachments that are attached to it, which gives you the conditions that you must comply to ensure that your development is environmentally and socially safe and sustainable. And that is if you're granted. However, the other, and very rarely, the decision will be to decline your application and not give you a development consent. And this is usually because the developer has not satisfied the requirements of assessment, either due to missing things or several requests that not have been adhered to. And here the options are, you can reapply the process and or go back and look for the information that's needed, prepare it well, and then reapply for a DCA for another assessment. Or if a developer is very unhappy with the decision and they do not agree with it, then they can make an appeal to the planning tribunal, which is that court selected independent panel, who then can assess the decision of the agency. And yeah, so that I think is just an overview of the entire process, but I now just want to give you some key takeaways and tips to remember. One of them is, the first one is always to plan your development early. And when you start planning, when you start thinking of that idea, please come into the office for a free consultation. And this is where we can really help you map out everything that you need to plan for physically and financially. And it will help you down the line as you go along your development process application, and also your application for any other permits that you need. And very key to remember to get all your documents together before you lodge your application. This will make your application assessment much smoother. Sometimes people just lodge half, and then we will wait 4 months while they're still trying to collect the other things. And then they complain, they say, you have not met your 10 days that you told us that the assessment will be done in 10 days. But again, the 10 days applies any other day if you have a complete package. And we really recommend that you complete your application package before you come into lodge. And Again, I really want to make this point that, this application process really isn't intended to be an obstacle to development or to be something that we will discourage people from actually going through with it. But really, it's there to ensure that, the development will be safe for you and for all the surroundings, and that people will socially accept your development and they won't oppose it or complain about it or, come to a conflict about it. And most of all, that your development is legal, that it has satisfied all the provisions of the law. And when your DCA is approved, you must comply with that conditions given. And failure to comply will result in your DC actually being revoked. So this is another common misconception by people is that once we give the okay, that's an okay for them to do whatever they want now because we've given the okay. So it's just like any other license that you get, your driver's license. When you commit a driving offense, like you crash your car or you hit somebody, they will take away your license. So that's the same application here for the DC. If we have given the DC, but you did not comply to the conditions given, or you added something else, it will be revoked. So it will be taken again away. And then what it will make your development illegal because now there is no consent to it. So that's, I think, a very key thing to remember. And we've talked about this and it's been brought up very well by our participants is that if you change an element of your development and it's different to the plans that you submitted, you must come back again to notify us. And you may need to reapply if it's already been, the consent has been given. But if it's during the application process, we'll just amend it for you at no extra cost. And thank you very much for your attention. I know that was a very and I will be very happy, as well as my colleagues are hopefully still online, to take any other questions or concern on the application process. But you can just ask the ladies now to pass away pamphlets that you can take. Please, if there's any other question.
Colleagues, any question? Please, if you're tired of sitting down, stand up and ask a question.
I think I burned everyone's brains.
Can we go back to slide? Sorry.
Sorry, I have
Quick
a
question. Today, how many ECs has PUMA revoked?
Okay, that's a very good question, and I don't really have enough. Maybe I'll ask Stella because this is actually in line with Stella's line of work. But it's a very rare occasion that we do this, and I want to say this because I want to highlight to you that we're very accommodating people in our office, that we don't like to be heavy-handed. And although at times we do need to be heavy-handed, we're also very accommodating, that we try and make sure that your development will work in a safe and legal manner. But for revocations, there have been cases of DCs that we've revoked. I don't know what the number is. Della, are you online? So for example, right now, this month, I know that there's like less than 5 that we've revoked this month. So I think that's a sort of number, maybe 3. Sorry? Yeah, so but annually, I think it'll be like a very small number, but usually this is because we have reached, a stalemate. No one is willing to compromise anymore, and they're not willing to change or to comply. Then that's what we will do, revoke. And if further to verification as well, is we will revoke, but if they still continue an illegal activity, then we go to court. And then we will apply for what we call an injunction, which is basically a court order to say, like, stop. If you don't stop, you'll be charged and either given prison time or what you call a fine. But I think for that kind of number right now for revocation, and again, because it is sensitive matters, revoking things that you have given to. So we will always try and explore ways that we can, negotiations and mediations before we get to that stage. But when it comes down to it, that no one is budging, especially the culprit, the person doing that thing, that is what we will do, we will revoke. And that will be a step for them to, change their ways and come back to the path of the light of the law. If not, then we will go to court. It's a very bad thing when we have to do that, like in terms of, because obviously someone's going to be punished.
Thank you. Yes, there's a question.
Following up on your revocation, is this to do with decisions that you have already issued? Officially, and then you revoke your own decision regarding?
It's a consent based, so it means that we've given you the consent and now we're taking it back because either you will not follow. So we're revoking the consent. So we're taking back the okay that we gave you. That we're not now. We're
Because they're not
okay.
compliant.
Yeah, because they're non-compliant.
Okay, so how about developments that have already been, executed? Like, for example, illegal ones or like that are not up to measurement standards, such as so many buildings every year, especially churches that are built from the main road. How do you correct those developments? I literally beyond revocation measures, but
that's a very good one, especially, so I'll take one situation of that is we come to find a development, let's say a building that's already been built, but there was no DCA. And, and obviously it's creating a problem somewhere. So what it is that we try and do is that we will now move beyond that and we will, use our powers, that we talked about. We resolve things that create an issue in the amenity side or the development side, or compliance side. So there's, I'll ask Stella to pitch in, but there's a variety of options that we do. One of them is that they will have to apply again, given the current situation that it's in. And we will recommend things that sort of reduce the impacts of that bad decisions that they've already made. That's it's kind of like our helpful way of trying to help them and ensure, that we don't penalize somebody. And they have to also, and this can be because, they genuinely didn't know that there was a permit to apply, or, and that they're now very eager to help rectify the mistake that they've made. So that's what we'll do. We'll actually have to cater some conditions to ensure that the impacts, will be reduced or mitigated. If they do not choose to, do even that option, what we have to do by the law is to take it to the courts then, because it's an illegal activity. And then the court can issue a decision that they must break it down and take, houses. So
can you instruct them to remove the physical part?
Yes, and yes, unfortunately, yes. I mean, it sounds, it's making me sound like a mean person, but yeah, so we go, usually it's like that. And first option we do, try to removing your whole building. Can we do these things to reduce it? If the answer is no, or if the person complaining is not happy with even those things, then we will have to say, oh, you must remove it. And if they do not remove it, even though we told them, then we'll have to go to the courts, and then the courts will tell them to. Or said, there's a lot of options. It's either compensation they pay and they get to keep it, but all those options are given by the court. But usually we have a lot of cases like that, and some of them are like that. Like, for example, someone built a house and almost 3 meters of their house is in someone else's land. I said, can be accidentally, can be not accidentally. And then, or for example, it's their entire eaves. So sometimes we just tell them, are you able to cut off your eaves and make sure you put guttering so the water doesn't go in? And, if the two parties agree to that option, then that will be done without having to remove the whole building. But if no one budges and someone wants, so that's the road people have to go down.
Thank you. Any question? Yes.
Thank you, Tulay. That was a very brilliant, informative presentation. I do recall some stories there, but very good. My questions are twofold. One has to do with revocation. When administrative agencies issue revocations, they usually come with conditions. I'm wondering whether when PUMA revokes a development consent, does that mean the consent is withdrawn, or is the consent simply being suspended until remedial actions have been undertaken by the developer? That's one. The second one is to do with the time bounds and the time frames that you talked about. And these are often subject of complaints and litigation and mediation. What has PUMA done in order to keep to the time frames? Because these developments often cannot wait because they're also have to meet their timelines. Can you talk about how PUMA then monitors its own work, and with a lot of it being the paper process and all that? Can you share with us how you go about that?
Well, thank you. So I think I'll attempt to answer your first question on the revocation, whether this is a revocation of consent or suspension while remedial actions are being taken. Usually when we use the term revocation, it's now, it's the final step. So usually the remedial has a step. It's always our first choice. We always choose to try and remedy or negotiate between parties before we then go on to, you know, the more serious part of actually taking back revoking the consent given. So usually that is the step that we do. And even revocation as well. It's not a decision that's done simply in the office. It goes to our board. You know, so it goes to our highest level of decision makers for them to support that decision as well. So we must also show them that we have tried every other avenue, the soft options of trying to fix this issue before we go down the hard option of, you know, revoking these official documents that we have issued out. So that's the answer for that, I think, and I hope Dylan can help me after with that answer. And then coming down to the timeframes, yes, you correctly identified that probably more than half of the complaints we get in the office is people not happy with the timeframes that we have issued. And of course, knowing our developers, there's, you know, timeframes that they're on. Their build-on needs to start immediately, and if they don't start on time, they're going to lose money. So there's a lot of decisions behind it, and we also are very, you know, sympathetic towards. But afterwards I'll ask the ladies, you know, about their experience in processing DCAs. But we do always try and meet the timeframes, and that is why it's so important that we ask that you have everything collected before you come into to launch the process. And then it will also give, you know, a developer all the right to say, I have given you everything. You now, you know, you don't need anything else from us. So why is it taking time? But usually our, if not maybe 90% of the time, people come to apply the application, something is missing. And they'll say, oh, can I just lodge it today? And I'll go home and prepare it and, you know, bring it the next day. And then, you know, they don't. And then they call back again and we can say, oh, I gave you my application in 2 weeks ago and you're still not done. But then, you know, we have to remind them, yes, but we're waiting for something. And they say, oh, you know, that's not what you're saying. You say 10 days from when I launched the application. So those are the little issues that might create conflicts within timeframes. But our office as well also has its part to play. And we also have natural restrictions that may hinder this delivery of service. And we should not be ashamed to say it, but there's only in our consenting team. So our consenting team is for all of Samoa, both islands, including the Bonono and Apolipa, if they do. But we currently have only 4 people processing development applications. And in a month, we get about, Jane, do you have a number? How many applications do we get about monthly? 80 to 100 applications. And then there's only there's only 2 10-day periods. If you think about it, in a month, there's only 2 10-day working day periods in that month that these 4 people then have to assess and do all individually and give it out. So sometimes we don't meet the timeframes that we say. And it's due to a reason because we naturally are restricted in our office in terms of numbers. Now, and not only assessment is not just done on your computer, they actually have to go out and visit them. So whether it's in Savai or the panel Savai ones, they have to go visit each site specifically. So yeah, it's a
Can I ask what's important here is when also mentioned is to plan ahead so that when you come in once and lodge it, everything's in and you will process it. And also not to mention we have referrals as well. So
Yes.
MCA and stuff.
That's correct.
And sometimes those agencies don't.
That's correct.
So partly it's not our fault.
I
And
agree.
because we can't issue the permit unless they.
I agree.
So it's like, it's not partnership.
yeah, I think that's what we're hopefully trying to highlight here is that it's the assessment has many facets or many steps within it. And it's a partnership, like we said, it's not just an assessment where PUMA makes the ruling and the number one say. We depend on not only our public people for their submissions, we also rely on our other government agencies who have their own specific technical knowledge to assess us with the assessment. And we must collect all of this before we give that one consent to a person. And yeah, so.
Thank you. Any question from this side? Yeah. Yes, Mr.
Thank you for the presentation. Can we go back to the slide where we usually you show the land? I just want to make a comment as I'm working with the customary land lease and that part there with the customary land and the top part which is which is written consent from the responsible staff or IT. That part there, I think it's getting more uneven. As you know, today most of them are not answering truthfully to who owns the land. As mentioned by in favor, some of them are able to just sign the paper, but there are some court decisions from long way before they came. So yeah, I think that part is coming more undeniable into years. I think it's causing a lot of headaches.
Oh, yes, I agree. It is, and this is a very tricky one to get right because again, it happens that way. Some Matai will sign it at Windfall, like it's not even the Matai of this village signing, things like that. But it's very hard because for us, we must seek the approval of the person who's responsible for it. And our culture says that, you know, generally lands are assigned to a title for custodian, so we must go down that way. But that's why hopefully, like, we really need this lands and titles confirmation to come from them to see what the most current, you know, decision is on a land. Because sometimes it's like that. It was a sound, you know, the family saying, "Oh, this is our highest chief." Then we knew that it got contested and he lost the title, and the title is actually vacant. But you know, that's entitled for that outburst. But you know, we are really trying. We agree with you, and we have found a lot of cases like that. That people are not truthful. Sometimes it's not even a title, you know. And obviously, we're not experts. We do not in the office know all the titles in Samoa and who has. So we really do also need. Like, you know, some sort of help on this. And that's what we're trying to, and that's what we rely on the courts and titles from. But can I also ask, like, and I think this is a very good networking opportunity that I see here with my brother here from the leasing customary land division. Do you have like I don't know, is there any way we can ask your division for help in confirming some of this, or do you keep record decisions?
Determining the land, the customary land ownership, we usually use our process. Our process goes through if the land has not yet had any confirmation.
Yeah.
Because we need the written confirmation. That's what we're using. So if there's no written confirmation, then we have to go through the publication process. We tell them to come and publicate the plan on the Sabah newspaper for 6 months. Before it was just 3 months, but now 6 months, and after the 6 months, then they will go back to the court and get a letter and confirm that there's no objection to the title and its ownership of the land,
And then register with.
and then
Okay, so I think, yeah, so usually for things like this, we recommend people to sort this out before and then come bring us the document. So for example, once it's registered with you, you can bring like a confirmation to say that decision has been registered before we even launch the application. And I think a good way of getting it from an agency or even is because you know it's verified. A person didn't make it up. And if they do, then it's a crime. It's punishable by law. I think maybe I would really like to have a chat with you after this on how we can sort of synergize our and even use, if we can, use your office to verify some of the information that's coming to us, especially in terms of the law. But I would like to.
Yes, please.
All the is to assessment for setback is that's a good opportunity for land.
Yes.
It always gives to us to see how land is involved or admit, because we already established a EIA review includes the information. So that would be a good platform for them to confirm that.
Oh, we would appreciate it. The more hands that we have into this decision making and the more people verifying the information, the better it is. So we appreciate that.
Ivan, are we recording all this conversation?
Oh, yes.
Thank you very much. Thank you very much. Thank you. Wait for this side and let's do our moderating this. So left hand side. One more question from left hand side. Yes.
What about if the hygiene is overseas, can still have to?
Thank you, Grace. That's a very good question. Yes, you do still need to get their consent, and it can be provided in a letter form that they can email over. And we actually have a lot of cases. That is this case that the high chief is living overseas, but they still must be contacted. I mean, we live in a day and age where almost everyone has a phone that can video chat or call. So it really is no excuse anymore. Someone saying, "Oh, I don't have a phone to contact my Sao," because mind you, these are people of your own family. The Sao is not like a government-appointed chief who you never met or know. They are people of your family, and you can network through your family to reach your Sao and have them, express their consent written off through a letter, or we've even had people calling, but calling sometimes we don't like because you don't know who's calling you. So we would like a written letter and signed. And yes,
Sure.
it's no excuse.
Thanks. Today, I really need to put this in our discussion. Something that really helped me with my case in terms of why I asked if you are still accepting hand-drawn site plans, because for my case it didn't help because it was inaccurate. So for one of the things that I use in preparing my reports for PUMA is Google Map. It's free. So maybe that's something that your officers can check with the applicants that come in, just show them where it is, ask them where the location is, and then then they can see the layout of the land and see those houses that will be affected by the development that they're proposing. The other useful thing was because of customer land, there are no official boundaries, but it's only the people that live on that land that have cultivated the land. They know the boundaries that they have cultivated for themselves, and that's something that can also be shown on the map. Just something that can help with
yes, thank you. And that is the current practice in the office. So for example, customary land, each family unit has their own general understanding of what their boundary is, and sometimes it's a coconut tree, it's the, you know, a hedge, that's what separates from that. So that's depending on whatever development that's coming in, we do, you know, use that assessment to say, okay, in your understanding, and even in our site visits that when we do, we will ask the neighbors, okay, what is your understanding of, you know, the boundary of your family? And, you know, is this a different family from your family unit? So yeah, we do try to do that. It's very tricky because there are no formal boundaries found. But that is a very good point as well that you raised in terms of site planning. It's something that we're really trying to, how do I say it, to encourage our people to get, you know, used to when you go plan, you know, providing proper site plan. Unfortunately, a lot of our demographic, you know, either can't afford that or don't. Sometimes the market out there, there's not a lot of people who can do it. But we are currently using that practice of, you know, just printing a map out of, you know, Google Maps, and then have someone write on it. But of course, there is always a margin error there. And hopefully we try and minimize that margin by when we actually go out into site visit. But, you know, unfortunately, I mean, we can't hide it. There will always be mistakes that will fall through the cracks. And I think it was the case in your case, so we apologize for that. But, you know, we will always try and find ways that we can do that, minimize the margin of error in our system. Thank you.
Thank you. Thank you very much, colleagues. I think we need a break. I really like the discussion. I can continue, but we need to take a break. Can we just show one slide there? And I want to set up one question and we come back and then we answer that question. Can we move a slide forward? Where we talk about the agencies or in the later part of your question. Where we have, yeah, this one. Colleagues, there is Ministry of Health there, for public health safety. So this is how I will frame my question. Yes, I was here when I joined SPREP, and I was approached by one of our colleagues from Ministry of Health, which is an important party of important stakeholder. And he asked me, Chappie, I've been given this EIA report. And the EIA report is to do with the proposed bumblebee canning factory. It came at one time, last few years. They want to do canning of tuna somewhere here. Yes, that's the one. And this friend of mine was given the EIA report, and I thought, hey, why am I asked to review this EIA report? So that's a question for you. Let me come back with answer that. Okay? Why are they given the EIA report to review? It's a canning factory, and they are given that EIA report to review. What's so important about public health safety for that particular development? So the answer will be given by this group. Okay, set. Let's take a break.